The ambiguity has sparked intense speculation, and some wonder whether the regulator is trying to reverse the fine. A source with a close connection to the situation has provided some insight regarding the filing. Nonetheless, a definitive explanation continues to elude. In the Ripple litigation, the CC may appeal documentation submitted to the SEC. While the appeal is being processed, market observers are keeping a careful eye on the events. They are aware that the SEC's action may set a precedent that is extremely important for the regulation of digital assets by the securities law of the United States. A complicated and nuanced understanding of cryptocurrency transactions is central to the discussion. These transactions, as the initial order made clear, are susceptible to scrutiny, not because of the token's possible timeline for the SEC's appeal. If the SEC decision to appeal the Ripple ruling has caused the troubled firm to experience a sense of déjà vu, the timing of what is to come may only serve to add to the sensation of being stuck in the same situation as before. The following scenario may play out as the months continue to drag on, which will result in another drawn-out conflict between the two parties. Although it is anticipated that the CC will submit its primary brief by the beginning of January 2025, the agency will probably make use of the 30-day extension that is permitted, so pushing the deadline into the new year. As someone who is never one to back down from a challenge, Ripple will almost probably engage in cross-appeal, with its initial brief landing occurring around the same time. It was indicated by the chief legal officer the opposition briefs will be submitted, with the initial deadline being at the beginning of February 2025. However, Ripple will extend the deadline by 30 days, bringing it forward to the beginning of March. Following that, it is anticipated that the reply briefs will be made public by the end of March 2025, which will mark the conclusion of the written arguments. After that, the groundwork will be laid for an oral debate, which might take place as early as September or October of 2025 under the right circumstances. There is a high probability that this confrontation will be closely followed, with representatives from both sides providing vocal defenses of their respective stances. The proceeding will culminate in a decision from the Second Circuit Court of Appeals, which will finally bring an end to the months of expectation that have preceded it. On the other hand, this is a time which will put a lengthy shadow on Ripple's ability to continue its operations. CC attempt to appeal, the cryptocurrency company Ripple was hit with a significant fine of $125 million after the dispute with the Securities and Exchange Commission, but the verdict appears to have been in Ripple's favor. Garlinghouse is persuaded that the strength of the finding cannot be disputed, even though the SEC has 60 days to file an appeal against the court's decision. His remarks were made during the Korean Blockchain Week 2024, which took place in South Korea. There is no plausible way for the Securities and Exchange Commission to argue the fundamental ruling, which is that XRP is not a security in and of itself. This is true regardless of whether or not they want to appeal the decision. There are concerns that the XRP token itself could suffer a significant loss if the Securities and Exchange Commission, however, it is not yet apparent whether the SEC is willing to take that bet after a lengthy 4-year legal struggle to appeal the ruling. The regulator has until October 6th to do so. Should this occur, the case may continue until the year 2025. Additionally, some speculations say Ripple has already paid the fee, which it was required to do within 30 days of the verdict. This time frame was specified in the ruling. Assuming that the payment is accurate, it may indicate that the legal struggle has been officially resolved. The case has been resolved. The United States Securities and Exchange Commission was dealt a devastating blow when District Judge Anelisa Torres reduced the penalty in the Ripple Labs case by 94. The application for relief that was submitted by the SEC was partially granted by the court, and hence a civil penalty of $125 was imposed rather than to say that this is a victory for Ripple. The industry and the rule of law would be an understatement. The obstacles that the SEC had been putting up against the entire XRP community have been removed, stated Brad Garlinghouse, CEO of Ripple. The order of the court regarding the SEC versus Ripple case. Supreme Court of the United States of America's order regarding the SEC versus Ripple case. A permanent injunction that would prevent Ripple from committing any other violations of Section 5 of the Securities Act, restitution of $876, 3 cents million with prejudgment interest of $198, 2 cents million, and a civil penalty that was equal to the amount of restitution were the three principal remedies that the Securities and Exchange Commission had sought for. Ripple was able to effectively argue against the claims made by the SEC. They contended that such a not surpassing $10 million In part, the request for relief and entry of final judgment that was submitted by the SEC was granted, and in part, it was refused. It was because of Ripple's argument that the penalty was drastically decreased. Ripple and the cryptocurrency community as a whole have achieved a significant victory as a result of the court's decision, which also forbids the company from committing any more violations of securities legislation. Ripple gains a victory. An earlier decision made by Judge Annalisa Torres said that the selling of XRP on secondary markets did not constitute securities transactions. The lingering problem is the fine that was imposed for initial sales to professional investors. Market participants regarded the fine as being very little, even though it was large. As a result, the price of XRP increased by 18, reaching 60 cents, indicating that the price of XRP went up image courtesy of CoinMarketCap, according to the judge's ruling from July 2023, which ruled that Ripple violated federal securities laws by selling XRP directly to institutional customers. The order that was issued on Wednesday followed that decision. Nevertheless, it was determined that Ripple's programmatic sales of XRP to retail clients through exchanges did not breach any regulations about securities issuance. The Securities and Exchange Commission's SEC attempt to appeal this particular portion of the verdict was unsuccessful. The ruling made by Judge Torres has consequences that are far-reaching for the cryptocurrency market as well as for the regulation of digital assets. It is possible that increased institutional participation in the cryptocurrency market could be encouraged by the transparent nature of institutional transactions while everything is going on from here on out. Because the matter of retail sales has not yet been decided, Ripple and the SEC are getting ready to engage in a protracted court battle. There are still a lot of questions that haven't been resolved, even though the latest verdict has provided some clarification. The cryptocurrency Ripple has made it plain that it intends to pursue a comprehensive settlement to build a transparent regulatory framework for XRP and other digital assets. On the other hand, the Securities and Exchange Commission still is likely to file an appeal against some portions of the verdict and may attempt to expand its regulatory jurisdiction over the cryptocurrency business. The ruling of the court about the fine to Ripple's fine, as determined by the court, image courtesy of the United States Court of New York. The Ripple case is a defining moment for the infrastructure of the cryptocurrency ecosystem. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and consulting with a knowledgeable professional.